Assalamualaikum and good morning to Dr. Abdallah. We are from Group 3 and we are going to present about the case of genocide happening between Gambia and Myanmar. Before we start, I will present the members in today's group. There are 6 members, which are Syafiqah Nur Zulaika binti Hassan, Aisyah binti Muhammad Rafiq, Atira binti Azman, Diandra Lau Yang Yang, Fazira binti Muhammad Shamsul Kamal, and lastly Susan Kaur Poching. There will be 2 presenters for today, which is me, Syafiqah Nur Zulaika, metric number 71506, and lastly Susan Kaur Poching, metric number 71719. Now we shall begin with the presentation. There are 2 actors of the case. The first one is Gambia, who is also the plaintiff for the case, as Gambia is the one who brought the case to the court. And the second actor is Myanmar, who is also the defendant of the case, who will be defending themselves against all allegations brought by Gambia upon Myanmar. Next, we will move on to the jurisdiction of the case. There are 4 articles that are used by Gambia to file a lawsuit against Myanmar. The first article is Statute of Court under Article 36, Clause 1. In this article, it is stated that jurisdiction of the ICJ falls on all cases that the parties refer to, as long as it is under the Charter of the United Nations or conventions in force. In this case, Gambia filed a lawsuit against Myanmar under the Convention of Genocide that is enforced by the United Nations. Secondly is Article 40, Statute of Court, and also Rules of Court, Article 38. These 2 separate articles explain basically the process of the case to be brought upon ICJ. Next, we will move on to Article 9 of the Genocide Convention. Both Gambia and Myanmar did not make reservation to Article 9 of Genocide Convention. In another way, they ratify Article 9 of the Genocide Convention. In Article 9 of Genocide Convention, mention if there is any dispute between states regarding the Genocide Act, it shall be submitted to the Court of Justice for the court to handle. Although the 2 countries, Gambia and Myanmar, are both located in 2 different continents, it is still legal for Gambia to sue Myanmar on the ground of Article 9 of the Genocide Convention that both countries did not make reservation to. As stated in Article 9 of the Genocide Convention, there shall no need for parties to have a particular situation to file a case against each other as long there are disputes of interpretation, application, or fulfillment of the convention that covers the dispute of the responsibility of a state for genocide. Next, we will move on to the purpose of the case. So the question of why Gambia had the audacity to file a complaint against Myanmar, according to Human Rights Watch 2019, it is mentioned that Gambia did this under the sole reason of humanity and religion cause. Next, we will move on to claims. Gambia has submitted 8 claims towards Myanmar on the issue of genocide to the court. The 8 claims are: 1. Committing genocide in violation of Article 3A. 2. Conspiracy to commit genocide in violation of Article 3B. 3. Direct and public incitement to commit genocide in violation of Article 3. 4. Attempting to commit genocide in violation of Article 3D. 5. Complicity in genocide in violation of Article 3E. 6. Failing to prevent genocide on violation of Article 1. 7. Failing to punish the genocide of violation of Articles 1, 4, and 6. 8. Failing to enact necessary legislation to give effect to the provision of the Genocide Convention and to provide effective penalties for person guilty of genocide or any of the acts enumerated in Article 3 in violation of Article 5 of the Genocide Convention. Also presented alongside the claims are evidence that are gathered by 2 special UN Special Advisor and UN Special Rapporteur, Mr. Adama Dieng of Sengol, and also Ms. Yang Hee Lee of South Korea, working under UN fact-finding mission on investigating whether Myanmar has indeed commit genocide. Alongside the claims submitted, there are also requests provided by Gambia to Myanmar for ICJ to consider if Myanmar is proven guilty. There are 5 requests in form of provisional measures. The first requests are: state shall prevent any acts which contributes genocide to the Rohingya. Secondly, Myanmar shall illegalize any military and do not commit genocide. Third, Myanmar is not allowed to destroy evidences of genocide. Fourth, Myanmar and Gambia shall not extend the subject of application. And lastly, both states provide a report to the court on the issue matters. Next, I will pass to Susan Korpoching for the second part of the presentation.
Well, thank you, Zulaika. I'll continue the presentation and talk about the solutions of this case. There are mainly 3 roles that have played a vital responsibility in bringing this case into further light. The International Court of Justice have accepted the issue request by Gambia, and the first verdict by them was an order of indication of provisional measures on 18 of November 2019. They also issued a legitimate injunction against Myanmar through the ICJ temporal steps. A panel of 17 judges at the ICJ voted and to order Myanmar to take all measures within its power to prevent genocide, which they said the Rohingya remain at serious risk of. Presiding Judge Ahmed Yusuf said Myanmar should report back within 4 months on how it was implementing the ruling. The measures are binding and not subject to appeal, but the court has no means of enforcing them. The court's decision clearly shows that it takes the allegation of genocide seriously, and the Myanmar hollow attempts to deny this have fallen on deaf ears. The second role that have played a vital responsibility is the international organization role. The court further relied on International Fact-Finding Mission IFFM report of 2018 September, which was endorsed by the UN Human Rights Council. The International Federation for Human Rights (FARES) reported that the security force of Myanmar committed violent acts against Rohingya in reproach for the attacks of August 2017 with a specific genocidal intent. The ICJ categorically noted that there are reasonable reasons why the Rohingya genocide should be concluded. The Council of Human Rights (WHRS) also included in its resolution and called for close and prompt cooperation between the court and other further investigations, including by the International Court of Justice and International Criminal Court. Thirdly, journalism roles. The international community condemned the violence. Tirana Hassan, the director of crisis response at Amnesty International, said the military atrocities have become exposed thanks to the courage of journalists, and that Myanmar authorities should have followed those who have been responsible for murder, rape, and torture. A report indicated 6 generals as the principal culprits of this genocide and recommended to examine all 6 for actions, which was reported by 2 journalists. And a member of the public also said that our situation is like being a prey gradually strangled by a python, and eventually we will be forced to give in all to the demands. This comment was made by a Burmese person, according to the BBC Facebook Live podcast. The alternate solutions for this case is to Myanmar open up its borders and allow United Nations investigators to collect evidence. This is mainly the cause why the ethnic cleansing in Myanmar has failed to be resolved. The government's cooperation and reluctance to admit to their crimes is very important in solving this case. As Myanmar is a repressed country, the need for politicians to be more democratic towards human rights rises. So in this say, Myanmar needs to change, and so does their politicians. In this way, the genocide case in Myanmar could be solved and further be prevented worldwide. And now I'll continue with the challenges of the case. First of all, stateless Rohingya. The minority, which are Muslims in Myanmar, are being denied the right of citizenship since 1982. Myanmar's government denies them citizenship and refusing to recognize them as people. Instead, they look at them as illegal immigrants from Bangladesh. The government claims that clearance operations against the militants ended on 5th of September 2017. But analysis of satellite imagery by the Human Rights Watch suggests hundreds of villages were destroyed in 2018 also. Secondly, the main challenge of this case is the lack of evidence. Myanmar rejects the crimes that they have done, but some journalists who have been finding more and more evidence are being imprisoned for breaching the country's Official Secrets Act. A few examples of journalists which have been punished for doing their duty are Wa Don and Ko Su-un. They have found images and disturbing reports when coming across to Myanmar and found out that Rohingya cultural leaders have been particularly aimed for by perpetrators. In conclusion, even though this case has been brought up many issues, there is a significant duty to look beyond mass murder to other offences perpetrated during genocide, which has always been overlooked in consideration of the murder and torture crimes. All in all, the majority of the population has been subjected to mass atrocities, including violation and offense against the ethnic cleansing and human rights. Thank you very much for your attention and have a pleasant day.